If the United States wants to be a venue for arbitration, if it wants to be the site of international arbitrations, it has to be attractive. It's got to be attractive. And in fact, there's a keen competition among locales around the world to be an attractive arbitration site and thereby attract a volume of arbitrations. Now, if you wanted to assess the attractiveness of a jurisdiction for arbitration, one of the first places you go is to see, what do its courts do? Are they cooperative? Are they supportive? Are they disruptive? What will be their involvement in this? The focus will probably be on what grounds will they annul an award, but it's more than that, because courts play a role throughout the arbitration.
The general principle stated in Section 3-1 is that courts should keep hands off of the arbitration process, because that is, in fact, the way it usually works and kind of ideally works. But there are circumstances in which courts can become involved in arbitration, and frankly, in those cases, courts actually help and sort of facilitate arbitration rather than intervene or interfere with it. And examples would be, and these are basically different sections in the draft, there are cases in which the parties haven't specified, that basically they come to a conflict or can't actually appoint an arbitrator, which is obviously a pretty fundamental step in the process. And they haven't provided for that in their agreement, and so one of the provisions, so Section 3 addresses the possibility that courts might actually step in to keep the arbitration clause or the arbitration from failing by appointing an arbitrator. There are also circumstances in which courts might help an arbitration proceeding be successful by issuing an order for provisional relief, kind of emergency measures, freezing assets, protecting evidence, something of that nature. Typically before there are arbitrators. I mean, that is a potential limitation of arbitration, that it's hard to do something without an arbitrator. And so there is a time lag, which arbitration institutions have been addressing. There are now emergency arbitration proceedings that make courts' role potentially less important, but it's still something that courts play an important role in.